Let's go ahead and get started on deposition and trial testimony. What are some of the pertinent, important factors you need to be paying attention to? Well, first of all, there's good news and bad news about depositions and trial testimony. 95% of the time, it's never going to happen. So it's pretty rare that you'll actually be in a deposition or trial testimony. Now, it will happen more and more as you become more of an expert and you start winning cases. What'll happen is your attorney, because attorneys would love to have somebody that knows what they're doing and knows how to talk in front of a jury. They would rather just do that all the time because that's where they get much bigger rewards doing that. So the problem is they don't have somebody that knows how to do all that. So that's why if you're really good at documentation and you're really good at explaining, where you know how to put things together and you can explain it and show the attorney and he can have the confidence in you to go in front of a jury, that's tremendous value. There's very, very, very few doctors that have that ability. Very few. You'll get a lot of business. You'll get a lot of personal injury business if you have that ability. So it doesn't happen very much. 95% of the time. And even when it does happen, you can go literally right up to the day before or the day of the deposition or trial, and they'll settle. So don't be surprised at all if that happens. They will most likely settle. Okay, and also what happens is they'll take your deposition first, and so the defendant, the insurance company, will take your deposition. And they'll kind of get a feel for how good you are and what are all the factors involved, and then they'll settle. So they'll kind of bluff it, and then they'll push the hand to see what they're really going to be dealing with in court. And then if they see it all comes together, then they settle. So that's kind of how that happens too. So just be aware of all that. And then just be aware there's a difference between a deposition and a trial testimony. Legally, they're the same. A deposition has just been made as a legal maneuver to where it allows professionals to do depositions but still live their life. In other words, still be in their practice. So most of the times the depositions are at the doctor's offices. Usually it's the insurance company because they're getting sued. The insurance company's getting sued. It's usually them, and they're not settling. So usually they're requesting the deposition. So to see what you got, what information you have, all that kind of thing. But just be aware that the deposition has the same meaning as if you're in trial. So don't think that it doesn't. It's exactly like you're in trial, okay? So just be aware of that. It'll typically just be in your office or maybe down at the attorney's office. That's all. And it's just a way to continue business without disrupting everybody's day and making everybody go down to the courthouse and sit around the courthouse. You can imagine how that would just block up commerce, you know? So that's the difference. And even now, so much that they're even doing on Zoom. You know, they're where you don't even have to go down to the courthouse sometimes, and you may do a deposition from Zoom. I did that one time. I was deposed, and the attorney that deposed me was in Kentucky. I was in Florida, and it was via Zoom. You may be recorded. There's nothing wrong with that. It's just like you would be in front of a jury anyway. And what a lot of the times the insurance company will do is record it. And again, they're seeing how you look. They're seeing how well you present yourself, how you look. You know, the better you look and the better you sound, the more they're going to settle, the bottom line. But that's what happens is they'll record it, and that's normal. So don't even worry about it. So that's some of the basics as we go into this. Do be aware that, remember, your patient's attorney is going to sue the insurance company. So, and it's usually for wrongful or bad faith effort. So it's your attorney your patient's attorney is the plaintiff. The insurance company is the defendant. And so you'll go first in a deposition or trial, you'll go first also, because you're going to state your case, okay, which is good. So now, where do you want to have these depositions? Well, you actually have a choice. You actually have a say. Obviously, they're not going to want to offend you too much. So you can say, hey, I'm going to do it. I'll do it in my office. So it's more convenient for you. You know, you may just want to do that. But a lot of times it's down at the attorney's office, usually in their boardroom, something like that. That's usually where it's at. Okay, if it is in your office, make sure you take down all the subluxation stuff, all the asthma, allergy, bedwetting. You don't want them bringing that up and you know, in the deposition. And they do. They'll look for the odd stuff because it obviously makes you look bad in the real world when he starts talking to you about how you treat cancer. You know, that's not a good thing. Okay. Then a lot of common questions I get is, what does it cost? Well, remember, the costs totally vary depending on what part of the country you're in. If you're in the Northeast, Southeast, Northwest, South, or the Midwest. And if you're in a rural area versus an urban area. So you can't say, you know, I can't tell you, oh, it costs, you know, you charge X. I couldn't tell you. What you do is you call down the local Trial Lawyers Association and just ask them, say, hey, what's the typical cost for a doctor's deposition? And it is what they call portal to portal. So it's from the time you leave to the time you get back home. So if you left your home to go to the deposition and then you came back from the deposition, it would be from the time you walked out your door to the time you came back. It's called portal to portal. Okay. If it was in your office, it's not that big of a deal. They'd schedule it at a certain time. Everybody gets there 10, 15 minutes beforehand, and it's usually 2-3 hours in a deposition. That's kind of a typical in-office deposition. That's how that works. Okay, so that has to deal where to take it. That has to deal with the cost involved. And then remember, there's a difference in a deposition if you are the treating physician. So if you're the treating physician, they can just subpoena you to come in and testify. Now that's different from being an expert witness. Remember, there's a difference between an expert witness and a treating physician. Well, they can call you in or you can go in and testify for any of your patients. But that's not true for an expert witness. Now, how to become an expert witness varies per state. That's not a standard rule. So the same thing is to call down to the Trial Lawyers Association and say, hey, what's the criteria for being an expert witness? Now, generally speaking, there's a lot of language that just says you spent a lot of time and energy in this field. I'm just paraphrasing. So there is no such thing as expert witness school, expert witness certification. There's no such thing as that. Okay, so I just want you to be aware of that. All right, so having said that, let's go into the deposition. A couple of things you do need to know about the deposition, and I'll share with you the common mistakes. You actually have to review the deposition with the attorney, your patient's attorney, and you do that in what's called a pretrial conference. You need to meet with that attorney, and if he doesn't request a meeting, you better request it. If he doesn't request it, it's because he's not that smart. So if he doesn't request it, then you damn well better request it. It's called a pretrial hearing, pretrial meeting. And all you're going to do is go over with them the flow of the case. You're just going over the basics of the case and the flow of the case. But this is where you need to introduce to your attorney, if you haven't already done this by now, that you have a trial testimony formula. And this is the formula. By the way, what I'm getting ready to show you is the formula of how I never lost a case in court. But remember, what's one of the criteria that I told you on why I didn't lose the case in court. I knew when not to go to court. So if they didn't have the 7 minimum categories of documentation, I showed that to my attorney and I said, hey, you don't have this, this, and this. You might want to just do what you can and move on. But I also, if they did have, I showed the attorney. I said, you got all 7 categories. And if they had more than that, I told them, you even have 2 or 3 in this category or 2. I said, you got a pretty strong case here. This is why. And you're the one that should be explaining that to the attorney. She doesn't know. They don't, it's going to amaze you how much they don't know about healthcare. It's going to amaze you, the ignorance, and it's really has nothing to do with them. You just project, chiropractors just project that they know a hell of a lot more than they do. And they don't. You're the one that knows all the details, not them. You're the one that knows how to put the details together. They know big picture stuff, but do they know the little details that all go together to build a case? No way. Now, the real good ones do, but that's far and few between. You're the one that has to show them how to put this case together. Like I told you, he'll have the basics of that he's used to doing, but you better pull this out and you better review it with him and say, hey, I need you to ask me the questions in this order, and this is why. Because what it does is it sequentially and logically builds the case. And it starts from credibility. We'll start from the doctor's credibility, chiropractic's credibility, the case's credibility. I mean, we build one hell of a foundation before we talk about the first positive finding or the first positive or the first diagnosis. There's a huge credibility, and we handled all the preemptive strikes. The preemptive strikes are the comments that they try to say to you to make you look bad. Those are called preemptive strikes. So we know pretty much what they are. And so we tell you how to handle it. As a matter of fact, we have our attorney ask them in a soft way so we can minimize the damage of, that's why it's called a preemptive strike. So we've gone through all the preemptive strikes, and then we start working and building into the case. We'll go into the mechanism of injury and associated findings and injury magnifiers. And it's like one after the other, it just keeps getting built. Then we go into subjective findings and hybrid findings and objective findings. And it just keeps getting built. And one of the best strategies to do is literally to have on a board the 7 minimum categories, like on a template. If you're in trial, it's great for a jury. I did this for my last expert witness jury trial. Remember, anything they can see is good. Remember, 55% of communication is visual, 36% is tone, 7% of the words. So that's why pictures are huge. Props are huge in trial. Simple props. So one of the things we did is we put the 7 minimum categories out. We had primary and secondary factors and multiple categories of diagnostics. And he would just fill it in. As he asked me questions, he would just go fill it in. And you saw this thing just get filled in, and go being bigger and bigger. And by the time he was done, this whole triangle was filled out. It was unbelievably impressive visually, very impressive visually. I did the exact same thing with ADLs, and it was unbelievably impressive. We listed the ADLs, which ones were positive, and then the degree of positivity, and then we associated all of those ADLs with the subjective, hybrid, and objective findings. It was an unbelievable visual that connected all this evidence, meaning having a permanent problem and permanent pain and restrictions for this person the rest of their life. Connected all these dots. So these are some of the main things you need to know about trial testimony. So let's go into the overview first, and then we're going to go into each question sequentially and individually, and you're going to want to learn them. You're going to want, some of these you're going to want to personalize to you, how many hours you've been practicing, and your continuing education hours and all that. But as far as the flow itself, This is exactly the flow that you want your attorney to be asking you the questions, because they put the base together and then they build it. That's what it does. So let's go ahead and take a look at it here.